All right, I went to the gym this morning and I threw on a blazer jacket after I worked out, but I actually have on my gym clothes underneath. And what I was thinking about is that I have spent various monies on coaches and I spend money on going to the gym with my membership. And I do all these things because I'm trying to make things better for myself. And when I feel better, I know that I'm going to do better for everybody else. And so I think of estate planning like that as well, where you shouldn't be afraid of spending money, kind of in quotes, spending money. You should feel like you are investing and you're investing in yourself as far as educating yourself and what that means to be prepared and protective and think about what can be beneficial for you and how that will also benefit those that you care about. Those that you care about is very broad. We have the people that are immediately in our lives, our close loved ones. We could also have our business interests and the business people that we so care about and the community that relies on the business. We can have charities that we so dearly care for, and etc. So when you are doing any kind of estate planning, don't think of it as spending money, but investing money. You're investing on yourself and the things that you care about. So really just, occurred to me again that we just need to turn our thoughts to the good that we're doing. And that can just mean becoming more educated about everything that can affect us, not just what did I get in a document or what does this do today, but really how is this helping me understand better and plan better? Because I always say we're in the midst of estate planning. What I mean by that is we can take an action or not take an action because we have all of these ideas and mindsets already programmed in us. And so all of a sudden, we can change course or do something that's either very beneficial or very detrimental. It's not about the fact that we have a will in place, but it's because our mindset has become that much more in tune with the idea of being helpful in all of the ways that estate planning can affect us. Do we have the right people in our lives helping us? Can we touch base with certain people who will help us? Do we need to check in with professionals, especially before big decisions are being made? How can we prepare before we take an action? Because sometimes we don't know what we don't know. And how can we communicate with people better so that we are putting ourselves in a position that we can be helpful for ourselves and our loved ones? So invest in yourself. Don't think of it as spending so much as investing. I've invested tremendously as far as coaching, as far as memberships, and all of those things. And I'm sure a lot of people as well can think of many things that they've spent money on, but just think of it differently. And this comes even out when we take our vacations and people, spend money on vacations or spend money on their homes, and that's wonderful. But think about estate planning as also being a part of all of that. It should be a part of everything that you do and you consider, and not just this afterthought for someday, when you need it. It's more about how is it affecting you and how you think about all of the activities in your life. Now, actually, what I really wanted to do was get back into this federal and New York estate tax exemption, kind of continuing on little series that I've started, because really what I think about it is that it's very interesting, of course, when you're in my world as far as this kind of planning goes, but really this kind of planning can be broadened to include people who just want to be open-minded to what can be helpful for them. So even if it's not estate tax planning, you can take certain moves that are very protective of assets and protective of people. And in that way, very much falls in line with the ideas about estate tax planning and thinking into the future and how you can make things arranged a certain way to fall in line with what you ultimately want. Now, I'm going to read a bit from a paper I have here so that I can get into those exemptions and the planning that I was talking about before without missing too many ideas that I wanted to get out. So first of all, I did mention in that last video that you want to think of all of your assets when you're thinking about, first of all, any kind of estate planning, but estate tax planning as well, because we have to get an idea of where you are at as far as all of your estate assets. And if you're single, we don't want you to forget any or leave any off the table, but especially when you're married, you have to think of both individuals' assets. It's not just your own, but also your spouse's, because we have to see where you as a married couple are falling in regard to taxes and estate taxes into the future, because both of your estates will eventually be taxed. And here in New York, we really want to take advantage of the New York estate tax exemption because we are a use it or lose it state, meaning you must use the exemption either during life or at your passing, or you've lost it forever. It can no longer be used. Your surviving spouse cannot port it or transfer it to their spouse so that it can pass through the second spouse's estate upon their passing. That is not allowed in New York. So it is a use it or lose it exemption. And so when we're looking at a married couple, we have to factor in both estates, because if we haven't taken some estate assets off the table for estate tax purposes, then the estates, both estates of spouses, so we have two estates that we're looking at, will be taxed upon the second spouse to pass. And so I mentioned the idea of having joint accounts not helping at all in this way, because instead of taking the first spouse's death, instead of taking some assets off the table, putting them into, I said, for an example, a credit shelter trust, all we've done is we've moved them into the surviving spouse's estate and stacked them up. And that one estate tax exemption here in New York may not be sufficient to cover that estate at that point. And boy, will loved ones be incredibly surprised about the estate tax bill at that point. Now, federally, we do have portability where we can port or transfer the spouse who passed, that spouse's exemption over to the surviving spouse, but it requires an estate tax filing at that time. Maybe that spouse will not be aware of it, or whoever the fiduciary is, or, things can go such that we didn't want them to, or ultimately that's not what should have been done, but things like this happen. And instead of waiting to see if there's going to be a problem in that regard, I would say get things lined up so that that's not going to be a problem. And I have talked to couples where they don't even know they're in the estate tax issue realm. So you can only imagine how difficult it could be for a surviving spouse to get a grasp of this and understand it all and do the appropriate things that are necessary, such as filing an estate tax return in order to get that portability on the federal estate tax exemption level. So that's the first thing. So we're getting a global picture here of all assets, whether it's an individual or a couple, and we have to look at all of the assets between the two individuals. All right, now we're talking about New York specifically. And I did mention that we have to use it or lose it as far as the estate tax exemption. Another point I want to bring out is that if the New York State taxable estate is greater than 105% of the New York State estate tax exemption, the estate does not get the benefit of the estate tax exemption at all. That's called the New York estate tax cliff. And now all of a sudden we have no exemption New York wise. And that is a disaster. So it's an incredibly important point to think about and to plan around as much as possible. Now, as well, New York does require that use it or lose it. I went through that. And then federally, we do have the portability. Now, remember, for federal purposes, we have the sunset of the federal tax exemptions so that at the end of 2025, the exemptions are cut in roughly half. We do have the inflation adjustment amount. We do not know where the exemptions will go into the future. So now, if you are single, think about this. if you are single, and let's say federally the exemption levels are going down, or not going back up to the levels that we know today, you have to have a serious conversation about using your exemption now while it is at the level that it is at. And that's what I mentioned in, I think, the first video, where you can use your exemption now. It would be wise to use it now as opposed to waiting to see what happens. Now, this can bring in other factors, where you're at in life, what are you thinking about, what are your assets, and all of that. But it's a very important point to consider as far as the sunset of the federal estate tax exemptions. Try not to forget anything. That's why I want to keep looking at my document here. As far as some of the options that you can think about as a married couple goes, when you're thinking about New York estate tax, federal estate tax, one of the ideas is creating an irrevocable trust, and you're going to provide the annual gift tax exemption to, or the annual exclusions to this irrevocable trust. So individually, you can provide gifts to other individuals in the amount of $18,000 per person per year. So that means that you are not using your estate tax exemption at all. $18,000 gift tax free, don't have to file gift tax returns, $18,000 per person per year. So an individual can provide a gift in this amount to an irrevocable trust as a way to part with assets year after year after year after year. Those assets are in an irrevocable trust, and you can do various planning within that irrevocable trust. As a couple, of course, you could think about gifting $18,000 for each of you per person per year. Now, when you step back and think for a minute here on gifting and estate taxes, the whole idea, and I'll put it really kind of simply and maybe a little awkwardly, is that the government, we have federal and New York, has decided what you can give away out of your estates without the government finding that you should have not been able to give away that much. The government now wants to tax you for giving away that much. And they're going to keep tabs. Are you giving away that much during life? Well, that's going to reduce what you can give away at death. If you haven't given away anything at life, then you can give it away all at death. But they're keeping tabs on life, death. Now, if you're under the annual exclusion, which now is $18,000 per person per year, that is not eating away at all for what you can give away at death. Now, people, when they hear, oh, I can give this away, it's not going to cause a problem for other things. No, that's not the case. Other things can mean you have creditor issues. You potentially are looking at getting into a nursing home or applying for Medicaid. There are instances where, people confuse all of this language and what they hear. And I always hear it, oh, I can give away so much, that won't cause a problem, right? No, this is only in regard to estate taxes. Estate taxes have become less and less of a concern for everybody, generally, given the exclusions, the exemptions that are allowed. And those exemptions used to be so much lower and caught so many more people, and so many more people had to think about planning just because of that. And those people now have to think about those old plans and redo them. But it's this idea that estate taxes are a consideration all on their own. And everything else, and there are a whole bunch of other concerns, have to be thought of and dealt with in another way, or at least thought of and talked about and understood in a totally different fashion. This is only about estate taxes. Okay, so I mentioned one idea is transferring assets via using the annual exclusion, the gift tax annual exclusion, to an irrevocable trust. Now, why does it have to be irrevocable? Well, a revocable trust doesn't do anything to get assets out of your control and therefore your estate. So you haven't done anything, right? Sure, you can transfer as much as you want to a revocable trust, but for estate tax purposes, you need to use an irrevocable trust, because the whole idea is that you're parting with the asset, whatever it may be, $18,000 in cash. You are parting with it. You are not retaining control over it in a certain way such that you really can't call it a gift, a completed gift, and therefore it's really still part of your estate. Okay, now I'm rambling because I decided I would do a video that just more and more just kind of rambles on. So I hope if you're listening to this, you're still in it with me, because I'm just going through some ideas as far as estate tax planning, but also I just want people to get this idea that planning involves opening your mind to, one, it being an investment in yourself and your loved ones, and even your business and your community. You are doing good in all of those ways. And that, two, there are options to be explored wherever you may be. All right, so now back to estate tax planning. Another idea is an irrevocable life insurance trust. This can hold life insurance policies, because guess what? If you retain certain incidents of ownership over a life insurance policy, that policy's proceeds will be taxed and taxable within your gross estate for estate tax purposes. Now, if you have other goals, meaning maybe you want certain creditor protection with the proceeds, or you want to make sure those proceeds can be distributed or flow a very specific certain way, as opposed to persons getting outright funds, especially funds in large amounts that could cause a lot of detriment to them. This is another way to even think about a life insurance trust. But for estate tax purposes, it's an incredibly useful tool, and there is a lot within this realm to talk about. Just know that it is an option. It is an option, let's say, if you have not started a policy or thinking of getting into a policy, you can start the trust and then immediately have the trust purchasing the policy. Or if you have an existing policy, you can think about transferring the policy to the trust. But there is a lot to talk about here, really, as with anything I'm mentioning, just trying to get some thoughts out. All right, so a third option for estate tax planning purposes would be separate revocable trusts for spouses. So this was kind of a classic strategy back when the estate tax exemptions were lower, where you look at assets that one spouse owns and the other spouse owns, and look at the assets that they jointly own, and think about where you can move assets so that you can roughly, if at all possible, split in half between the two spouses assets to their own revocable trust, so that each spouse, upon that spouse's passing, can soak up the, especially here in New York estate tax exemption, and it being very easy, if you can say it that way, easy as far as that kind of planning goes then into the future, where we already know what that spouse has, what is going to go into a potential credit shelter trust, and so on. So that's a possibility as far as separate revocable trusts. What would happen then upon that spouse passing, or a spouse passing, is there is this subtrust where the credit shelter trust finally does kick in. And then at that point, it would be an irrevocable trust. And this idea, or this terminology of credit shelter trust, can be called different things. I'm just calling it credit shelter trust because I think at this point it makes the most sense as far as what it's meant to be. All right, another idea is a spousal limited access trust, which is an irrevocable trust in which one spouse is setting up and funding it with larger amounts. So you are going to be parting with a substantial amount of assets in order to make sense of this. And then you're going to come up with terms as far as the spouse benefiting, the other spouse benefiting from the trust. And again, this has a lot to it. And one of the things you may have heard about is the reciprocal trust doctrine, where both spouses are setting up such a trust, but the terms are too similar, and therefore both trusts can be unwound and you haven't done anything at all for estate tax savings and so on. So it's an area, of course, that you're going to be concerned about. One way to not even have the concern is that only one spouse sets up the spousal limited access trust, but it's an irrevocable trust. And you're considering how you're going to plan for the other spouse, how they can benefit, and how you can take advantage of the estate tax exemptions while they are high. The other idea is that you could set up a spousal limited access trust and have that be ready to accept the credit shelter trust that is going to be coming from another source upon your passing. So as opposed to all the funding happening during life, you can potentially have that spousal limited access trust funded or funded partially with the assets that you intend for it. And then later on down the road, it can be slated to receive the credit shelter amount from another way, even from a revocable trust. That's an option. You could also have a joint revocable trust, and that joint revocable trust is actually slated to divide at the first spouse's death. And that's another way that we try and take advantage of the applicable exemption amounts, credit shelter at that point in time. All right, now all of this, I do want to say that you're trying to not just plan for estate tax purposes, but plan for being very protective of assets, of people, of taking advantage of avoiding probate, taking advantage of managing assets during your life. You know, I think of so many examples where management of assets during a person's life was just not thought about in the planning process. It was only this idea that, you know, well, we have a payable on death designation, we're all set. Well, first of all, nobody has a crystal ball. We don't know what will happen into the future, and you can't pretend that that's going to take care of that asset. There are a whole, bunch of issues that could go wrong there. But let's just think about the phase prior to passing. Mismanagement of assets, elder abuse, powers of attorney coming in and changing things. Even, let's say, a new power of attorney coming in because someone wants to take advantage of somebody. There's so many examples where management of assets is critical. And that's something that I think gets missed often enough, that people have to have that in the back of their minds all the time. How am I thinking about managing this asset, that asset now into the future, 5 years, 10 years? How is this asset going to be protected, and therefore people being protected as well? So I do want to mention that whatever estate tax planning can be done, there are other goals that are always intertwined with the planning, and that's such a great thing. So let's go back to where I started, which is I did a quick workout. It's a pretty quick workout, but it made me think that, we invest in ourselves in so many ways. We have fun in so many ways. We take vacations, we work on our houses, we hire coaches. Let's intertwine estate planning in what we do, and especially in our mindsets. Let me just bring out one other example. I was working with clients who were thinking of some planning. They just weren't really ready to take action and kind of, were always late and getting back to me, never really did get back to me. And what happened was, and I don't want to talk too specifically about it, was something completely out of the blue came and really, unfortunately, changed their circumstances overnight. And it was just another example to me that, you know, you've got to interweave estate planning in what you do because it's that important. And I can think in my own life how I didn't understand planning, and planning opportunities even meant talking to people who are interested in helping and paying people who are going to give me neutral advice and sometimes tough medicine, because that is going to be crucial. And so never cut yourself off from those opportunities. So as you can see, I think I'm ready to just kind of say a whole bunch of things, because a whole bunch of things are always on my mind. But I hope this did help. Estate tax planning, or planning without estate tax concerns, it's important. Take your opportunities, even if it means taking one action and coming back to it as you can, but don't let it sit around as far as, you know, that thing that you never take action on. I believe that there's little things that we can all do. All right, so this is Ruth George with Ruth P. George Law, PLLC, Trust and Estate Attorney. This video, as with any video I do put out, is for educational purposes only. It does not establish an attorney-client relationship, and I look forward to seeing you on another video.